People of the State of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Juror number 1009 indicated that she wishes to speak with me, so I'm going to bring her in. All right, let's bring her in, please. The record should reflect that juror number 1009 is now present in the courtroom. Good afternoon.
Good afternoon.
I understand that you want to talk to me.
I do.
What's on your mind?
Well, I'm sorry for the inconvenience. I had lunch with a coworker today, and she stated that my CEO said to tell me hello and then proceeded to recount a conversation that they were having in which he said to her that he had read an article that said 3 jurors were dismissed for texting. So I stopped her and told her that she wasn't allowed to speak to me about that, and so thought I needed to report it.
All right. Well, first of all, you don't have to apologize. It's not an inconvenience, and you did the right thing. This is exactly what you're supposed to do. Let me ask you, anything about that you think would affect your ability to be fair and impartial in this trial?
No, sir.
And anything about that you think would influence or affect any of your decisions in this trial?
No.
How about your deliberations in this trial?
No, sir.
And if I give you an instruction that says that you cannot assume or speculate about the veracity of what you heard, would you follow that instruction?
Yes, sir.
All right. And I'm giving you that instruction now, so will you promise me that you will follow that instruction?
Yes, sir.
Will you also promise me that you will not talk about this to any of the other jurors?
Yes, sir.
Okay. Let me have you step out for just a moment, okay? Thank you. The record should reflect that juror number 1009 has stepped out of the courtroom again. Are there any other questions that the people would like me to ask her?
No, sir.
Any action that people would like me to take at this time?
No, sir. I commend the jurors that have had the forthrightness and candor to come in and talk about even these kinds of matters.
I agree. Anything from the defense in terms of additional questions that the defense believes I should ask?
Not this time.
And any action you're asking me to take?
Not now. Thank you, sir.
Okay, thank you. All right, let's bring the jury in, please.
While we're waiting to bring her in, the defense was planning on bringing this up with the court later, but is that the reason that we observed the court sending Ms. Gerlings over to her and then Ms. Gerlings relaying a message back to you, and we wanted to inquire what that was about?
That's what it was about. She told one of my staff members as they were coming in that she needed to talk to me. And so one of my staff members wrote me a note saying, Juror 1009 wants to talk to you. When I got the note, Mr. Brockler was in the middle of his direct examination of Mr. Garcia, and so I asked my staff member to inquire if this could wait or if it was something that we needed to talk about right away. And she indicated to my staff that this could wait. So I figured that we could proceed and then take it up at the break. So. And I meant to mention that and I forgot. So thanks for reminding me. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Mr. Garcia is on the witness stand, and I remind you, sir, that you're still under oath. Mr. Brucker, do you have any more questions for him?
I do, Your Honor.
You may proceed.
Thank you. Sir, one of the things I wanted to ask you about is during the time that you had the chance to interact with the defendant, did he ever describe for you the role that school played in his life, how important his school was to him?
He generally saw school as very important to his life.
Did he ever describe to you anything more important to him than school?
Not that I know of.
During the time that you had the opportunity to interact with and observe the defendant, did you ever see him do anything that was outside of social norms or socially outrageous? Or
No.
did he ever, outside of the G chat that you and Miss Dada asked him about, did he ever describe for you or talk with you about anything related to human capital,
No.
increasing his self-worth by killing people,
No.
feeling better by killing people?
No.
Ever talk to you about hallucinations?
He said he didn't have them.
When you confront... Can I have one moment, Your Honor?
You can.
Reference you made that he didn't have hallucinations. Is that contained in one of those G chats that we admitted?
Yes.
Okay. When you and Miss Dada confronted him about the G chat with her, the one about human capital, what was his demeanor or response to that? Now, you've told us the words, visibly.
So he didn't seem like it was a big deal.
You had indicated that that presentation sometime in mid-May would have been the last time that you saw the defendant. Is that fair?
Yes.
Prior to that, had he ever told you or showed you that he possessed a cell phone stun gun?
No.
How about a folding knife?
No.
Did he tell you that he had purchased or intended to purchase 2 canisters of tear gas,
No.
a gas mask and a gas mask filter?
No.
That he had attempted to purchase a handgun online?
No.
From September-ish of 2011 until that last time that you saw him, in terms of his appearance and hygiene and demeanor and consistency coming to class, all of those observable things, was the defendant the same person in mid-May that he was in September when you met him?
Yes.
I have nothing further, Your Honor. Thank you.
All right, cross-examination, Ms. Higgs.
Your Honor, if I could just have one moment, please.
Yes?
My mic is on. I don't have any questions for you, sir. Thank you, Your Honor.
All right, let's see if the jury has any questions. No, it doesn't appear like the jury has any questions. Mr. Brockman?
This is embarrassing, Judge. I'm looking at my scrawl here. I left out one question, and with the...
Your Honor, we object. They finished their direct.
I'll allow you to ask one question, and then I'll give Ms. Higgs a chance to cross-examine.
And please forgive me. I'm sorry, ma'am, too. Sir, during the time that you knew the defendant, did you ever find him to be a hasty decision-maker?
I did not. He is very deliberate in his choices.
All right, Ms. Higgs, any cross-examination?
No, Your Honor. Thank you.
All right, thank you. And the jury doesn't have any questions. May Mr. Garcia be released from his subpoena?
Yes, sir.
Is there any objection?
No. No
Okay,
objection.
Thank you. All right, sir, thank you.
What do I do with this?
You can give it to me. Thank you. Joyce. Joyce. Oh, sorry. All right, call your next witness, please.
We'd like to recall Carrie Imey.
Good afternoon again. I'll remind you that you're still under oath, okay?
Okay.
All right, so you may have a seat. And then, just for the record, remind us of your name again, please.
My name is Carrie Dawn Imey.
All right. Mr. Orman.
Thank you. May I approach the witness, Your Honor?
Yes.
I've handed you what's been marked as People's Exhibit, is that 1249?
It is.
Okay, and I'm going to actually hand you another one, 1250. Counsel's reviewing that, Your Honor.
Okay.
Have you taken a look at 1250?
Yes.
Are both of these emails that were contained within the batch of emails that you acquired relating to the defendant's email accounts when requested via court process?
Yes.
And have you looked at these? Do they actually have the Bates numbers that you created?
Yes, they do.
Let's talk about the first one, 1249. Who is that sent from?
Objection, Your Honor. This has not been introduced into the evidence. I object to any witness reading from it or introducing any evidence from it.
Sustained.
Right. The individual that it's sent from, is he an employee of the University of Colorado?
Yes.
And is he a professor at the University of Colorado?
Yes.
And for 1250, can you look at that, please? The person that is sent from, is that an employee of the University of Colorado?
Yes.
And is that a professor at the University of Colorado?
Yes.
And would the information contained in 1249 and 1250 constitute the activities of employees of the University of Colorado?
Yes.
Additionally, and you have previously stated, I believe, and correct me if I'm wrong, that the University of Colorado is a public agency. Is that correct?
Correct.
Is in fact part of the state of Colorado.
Yes.
For both of these records, would these have been made in the ordinary course of business of the University of Colorado?
Yes.
Would the individuals who created these records be acting in the routine course of their business?
Yes.
Would the input procedures for creating emails and sending them be an accurate means of memorializing information?
I'm sorry, can you repeat that?
Sure. Would the sending of emails through the University of Colorado servers be an accurate means of memorializing information?
Yes.
The dates on these emails, would the information have been stored on the CU server in a reasonable period of time within the creation of these emails?
Yes.
And would the people who sent these emails have the information and have firsthand knowledge of the information sent within these emails?
Yes.
Move to admit 1249 and 1250, Your Honor.
All right, is there any objection?
Yes, Your Honor, there is.
All right, why don't you approach, please?
If I could have just one moment.
Yes.
As well, thank you.
All right, thank you for your patience, folks. The objections are overruled and both exhibits are admitted. That's P-TR-1249 and P-TR-1250.
I have no further questions, Your Honor. Thank you.
Is there any cross-examination?
No, Your Honor, there's not.
All right, ma'am, thank you.
Still under subpoena?
Is she still under subpoena, subject to recall?
I think the defense had asked her to remain under subpoena last time we had her, so I think she is.
Okay, so you may be called again.
Okay.
But if you run fast enough, probably not today. Joyce? Here you go. Thank you. All right, call your next witness, please.
Robert Feinstein, Your Honor.
Could I have you raise your right hand for me so that I can administer an oath? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, please be seated.
Your Honor, could we approach
Yes.
briefly about instruction?
Yes. All right, please tell us your full name and spell your first, middle, and last names.
Robert Eric Feinstein, R-O-B-E-R-T, E-R-I-C, F-E-I-N-S-T-E-I-N.
And it's Dr. Feinstein, is that right?
Yes.
All right. Members of the jury, I need to give you an instruction. The court has admitted the testimony of Dr. Feinstein for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Does everybody understand that? And everyone's nodding their head yes and saying yes. All right. You may proceed, Mr. Brockler.
Thank you, Your Honor. Sir, would you please tell us what you do for a living?
I'm Vice Chair in the Department of Psychiatry at the University of Colorado School of Medicine and Practice Director of Ambulatory Psychiatric Outpatient Services.
Are you a medical director?
I am.
I'm sorry. Are you a medical doctor?
Yes, I am.
And how long have you been a licensed and practicing psychiatrist?
Your Honor, I'm going to object. This witness has not been endorsed as an expert. I don't think it's relevant.
Overruled.
Go ahead, sir.
33 years I've been in practice.
Back in the period of time between March and June of 2012, were you in these same roles that you've described to us?
Yes.
Did a Dr. Lynn Fenton work as a psychiatrist under your supervision?
She worked in my department. I was her mentor, not her supervisor.
How many other psychiatrists were you mentoring at the time?
Objection, relevance.
Overruled.
Go ahead, sir.
Probably around 20 psychiatrists.
Now, for this particular case, and you know the case that you're here on, were you, and that's yes?
Yes.
Sorry. Were you called in by Dr. Fenton to provide some additional consultation and assistance?
Yes.
Am I using the right professional terms for that? What would you call it?
Yeah. She asked me for a consultation on the case.
Is that unusual?
No. That's a regular activity. All the psychiatrists consult with each other on a regular basis. I do consults for other psychiatrists on complex cases or cases with a question, 3 or 5 cases a week for years.
Here's what we've been told as of yesterday, is that you participated in 2, and should we call them sessions or something else?
Sessions is fine.
2 sessions, one on May 31st, 2012, and one on June 11th, 2012. Is that accurate?
Yes.
Now, prior to the May 31st, 2012 session that you sat in on with the defendant and Dr. Fenton, what information had you been provided leading up to that?
So I first heard about the case on April 23rd during a regular routine meeting that I have with Dr. Fenton on a once-a-month basis. She described the case that she was, and she asked me to consult.
Did it make sense for you to consult in your opinion?
Sure.
And so did you do anything else, read old notes, get up to speed in any sort of way before the May 31st session?
I spoke with her about the case, and I spoke with Margaret Roth about the case.
Were you aware what medications the defendant had been on leading up to May 31st?
Yes.
And based on your knowledge of everything that had been given to you, did those seem like the appropriate medications to be on?
Yes.
Section, Your Honor, calls for opinion. This is not an expert.
Overruled. This is not an expert opinion. He's talking about his involvement with the defendant as a treating doctor.
Thank you, sir. On May 31st, do you remember where you went to have this session with the defendant?
In Dr. Fenton's office in Building 500 on the Anschutz Medical Campus.
Who led that session?
I did.
In fact, did Dr. Fenton really say or do much in that session?
No.
I keep saying the defendant, this individual here in the blue and white striped shirt with the glasses and the beard and the mustache, is that the person that we're talking about?
Yes,
And you know him as James Holmes?
I do.
Tell us about that particular session. When you went into it, what were your goals?
Okay. So I was asked to look at 6 different issues. Issue 1 was to give an opinion about a differential diagnosis for the patient. Issue 2 was to give an opinion about medications that he was on for that. Issue 3 was to look at the therapeutic alliance that he had with Dr. Fenton and tried to decide if there should be a change in the treating provider, which might have been a change to me. I was also there to assess his homicidal ideation and what that was about and whether or not there was a need for an involuntary commitment. I was also there to try to develop a relationship with him and see if we could work out a future treatment plan for his care and treatment.
When you say therapeutic alliance, what are you talking about and why was it important for you to assess that?
So from what I heard from Dr. Fenton, she was unsure whether their alliance was good enough that a productive psychotherapy or treatment service would go on with him. So I was asked to assess that alliance to see if there was a better change in therapists from Dr. Fenton, potentially to me or potentially to somebody else.
How important is it to any potential successful treatment that there is a, I guess, productive and strong therapeutic alliance?
Extremely important.
Now, in terms of being able to treat and assess someone like the defendant back in May of 2012, how much do you rely upon the words they tell you, the things they're willing to share as a, I'm going to say, a historian?
That's the primary source of information, mostly what you get and what you need.
Now, as you came into this, you said one of your other goals was to assess homicidal ideation. Was this the first patient that you'd ever had that had expressed homicidal ideation?
Objection, Your Honor. 702, this is not an expert witness. His prior experience is not relevant.
Overruled.
Go ahead, sir.
And I think Dr. Fenton was asked a similar question yesterday without objection.
Could you rephrase the question, please?
Yes, sir. Was this your first patient you've confronted that had what we called homicidal ideation?
No.
You had a bunch?
Many.
Do they always appear like the one that you were, the homicidal ideation you were described by Dr. Fenton going into this meeting?
No, there's a variety of patients who express wish to hurt others, wish to kill others, with a variety of different diagnoses.
We'll get to this as we move through the rest of this, but is that, in the way you treat, is that sufficient for you to simply commit someone, simply having homicidal thoughts?
No. To decide about commitment, you have to do a violence risk assessment, which involves looking at many other variables other than just their thinking to make a decision about violence risk.
Had you, in the past, made the decision to commit people against their will based on things they'd told you?
Many times.
Your Honor, I'd make the same objection.
All right. Members of the jury, I'm going to send you out for just a little bit. Let's take a break, okay? We'll take 10 minutes, see if I can address some things. Thank you. Please keep in mind all my advisements during the break. Doctor, we'll have you step out, please. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. I'm not sure I'm following. Dr. Fenton testified yesterday. The defense wanted to introduce all her medical records. Initially, the people objected, but eventually they agreed to admit the records, but the defense wanted all of the medical records admitted. Dr. Fenton's records include things Dr. Feinstein said and his involvement in the case. Not only was there no objection to that, the defense wanted that information in. There were questions of Dr. Fenton similar to the ones being asked of Dr. Feinstein. There was no objection. In fact, the defense elicited some of the same information. I'm not following. What's the objection?
Your Honor, we understand that Dr. Feinstein is a treating physician for Mr. Holmes and that he would be testifying with regard to his treatment of Mr. Holmes, but any attempts to bolster his expertise or his opinions or his actions with regard to his treatment of Mr. Holmes by getting into his work with other patients or his prior expertise or what other patients of his have presented like or how he's addressed that with other people is simply not relevant to his treatment of Mr. Holmes. So I'm not objecting to his testimony with regard to meeting with Mr. Holmes or talking with Mr. Holmes or what happened with regard to that or his conversations that he's had with Dr. Fenton. It's simply this bolstering of his expertise when he is not offered as an expert in this case.
It's not bolstering. It's relevant because it goes to the actions he took, just like it was relevant yesterday with the actions Dr. Fenton took. If this was the first time Dr. Fenton and Dr. Feinstein had heard anyone say that they wanted to kill people, then presumably they would take certain actions that they had never taken before. Part of what Dr. Fenton explained yesterday is that she's heard that before and that that's not enough to take certain actions that sometimes psychiatrists take and sometimes psychiatrists are required to take. So it's relevant to that. It's not bolstering. And it's not because he's testifying as an expert witness and offering expert opinions. He's a treating doctor, just as Dr. Fenton was, and I think it goes to what actions he took, what he believed, what actions he didn't take, what he may not have believed based on his interactions with the defendant and based on his interactions with Dr. Fenton. So I disagree with you that all of that is irrelevant. In terms of his background, I think it's relevant because he's a treating physician. It's still relevant to ask him what kind of background he has, what kind of experience he has. So I think in terms of having one or two questions about his background and his experience is appropriate, even if he's not testifying as a retained expert, but rather testifying as a treating physician.
And Your Honor, I didn't object to the first couple of questions, but I think this is repeated throughout the direct testimony already about his experience and what else he's done elsewhere and how many other people he's talked to and what he's talked to those people about. I'd make a standing objection to those types of questions. If Mr. Brockler wants to move in directly to what he did with Mr. Holmes, I wouldn't be objecting to that.
All right, the standing objection is denied. If you want to object, you need to object per question if you think there is an objectionable question asked. So to the extent that that's a request, to have a standing objection, it's denied. I disagree that there have been a bunch of questions or a lot of questions about this. I think there were a couple of questions. I think it's relevant to have him testify about what other patients he has had who have said anything about killing people for the reasons that I stated. I think in terms of whether he thought Dr. Fenton had prescribed the appropriate medications, you objected to that. Of course he can testify to that. That's one of the reasons why Dr. Fenton brought him in. She brought him in to see whether he had any other ideas, whether he thought that the medications were appropriate, whether he thought there were other things that should be done. Dr. Fenton testified about that. The records that you wanted admitted yesterday and that were admitted talk about that. So again, I don't think I follow the objections. I don't get the objections. I understand the objections, but I don't get why they're being made. The objections are overruled, and if you want to object further, you'll have to do it on a question-by-question basis. But from where I'm sitting, the only difference between Dr. Fenton's testimony yesterday and Dr. Feinstein's testimony today is that there is a different defense attorney. All right, let's bring the jury in.
Your Honor, while we're doing that, can I give the court a logistical update of where we're at, given the time?
Yes.
Dr. Feinstein has indicated that he is available tomorrow, but not until the afternoon. I've spoken with Ms. Higgs about this, and I don't know if the court's inclined to ask the jury if they'd stay a little bit later, or if the court wants to say, let's bring him back in the afternoon on Thursday. I just wanted to advise the court.
How much later would you need him to stay?
That is largely dependent on cross-examination. I think Ms. Higgs had told me she thought she could possibly do it in 30 minutes.
And how long do you think you need for your direct?
I'd probably need at least 25 minutes.
All right, in that case, let's just plan to bring him back tomorrow afternoon.
Yes, sir. Thank you.
Okay, thank you. Let's bring him in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, folks. Thank you for your patience. I appreciate that. All right, Mr. Bruckler, you may resume your direct examination of Dr. Feinstein. Dr. Feinstein, I remind you that you're still under oath. All right, you may proceed.
Thank you, sir. Doctor, going into that May 31st meeting, and you've set the stage for us where it took place, was the defendant on time?
Yes.
And describe for us how he appeared and what impact that had or significance to you in assessing him initially.
Okay. He appeared in sort of common, ordinary pants and, as I recall it, a button-down shirt. He was clean. His hygiene was appropriate. He looked like many graduate students look like in his program.
Now, as part of an initial reaction as you begin to go through this assessment process, why are those things significant, that he was on time, that he even showed up, and that he was dressed the way you described?
It gives you an indication as to whether or not he's organized, taking care of himself, mostly self-care issues. Looks like he was taking care of himself.
You ended up having a session with him for about how long? Do you remember?
45, 50 minutes.
During that time, tell us what was significant to you about your observations of him or answers that he gave to your questions.
What was significant? He was
let me start here. I'm sorry, since you didn't answer, you had just started.
Sure.
Did you introduce yourself to him, and was he okay with you being part of this process?
Sure. I began the interview by asking him if he knew why I was there, and he said that he knew I was there because Fenton had asked me to join.
Now, he uses the term Fenton, not Dr. Fenton?
Correct.
And how did you interpret that?
Slightly devaluing, putting her down a little bit.
Is that unusual?
Not unusual. Patients will sometimes do that when they're mad at their providers.
And so what did you do after that?
So I told him I was there as a consultation to Dr. Fenton to ask some questions, and he immediately asked me if I was going to lock him up.
And tell me what was significant about that to you.
I asked him why would I need to lock him up, and he didn't answer. And that was pretty significant in that much of the time to many questions, not just ones about homicidal ideation, he wouldn't answer, be non-responsive, give a little nod of assent. Very rarely did I get a direct answer to any direct question.
First off, is it unusual for patients to worry that they're going to tell you something that will result in them being locked up?
No, that's pretty common. People are afraid when they see a psychiatrist that that's what we do. If any of you have ever seen One Flew Over the Cuckoo's Nest, that's kind of an image that comes to many psychiatric patients when they see a psychiatrist. They're afraid we're going to lock them up.
I'm asking you to come up with a percentage here, and I didn't tell you I was going to do that, but do you have a sense of, throughout this session, how many of the questions or what percentage of the time was spent with the defendant not being verbally responsive to your questions?
Percentage of time, probably 10%. He made it clear when he didn't want to answer a question. There were many questions he didn't want to answer. And then we moved on to other topics.
Do you remember topics other than the ones you just mentioned, the why would he get locked up and the homicidal ideation, that he did not provide answers to you for?
He didn't provide a lot of answers about his relationship with his girlfriend. He provided very limited information about how he was doing in school, how things were going with his exam. He was very restrictive in telling us any of the people in his life. So I never heard a name of who his girlfriend was. I never knew who any of his friends were. He was in general very restrictive in giving me a wide range of information throughout the whole interview.
Did you explore with him in that interview about his relationships with his family?
I did.
Why was that important?
So I wanted to assess his attachment to his family members because that's a little bit of an indicator of how he'll do in therapy, whether he can attach to a therapist, whether we can work with him. So I did ask him about his family.
And did he provide you information about them?
Yes, he did.
Did you also ask him about any thoughts that he had about people in general aside from homicidal thoughts? And specifically regarding hating people?
We did have several conversations about that. Statements such as he hated humanity, but whenever those kind of questions related to homicidal came up, that was usually followed up by me with questions of, did he have a specific target? Did he have a specific plan? Did he have any access to weapons? And most of the time, I got a kind of evasive non-response to those questions, occasionally a little nod, which you'd have to interpret.
Back to the part about he hated people in general, did you ask him why?
I did, and that led him to discuss a little bit of his philosophy of life, which came up when he told me he was reading Nietzsche, that he was reading about the Tylenol terrorist and Ted Kaczynski, and that led to a little discussion about why does he hate humanity.
And what did he tell you about that and those reading materials?
He said that he hated everybody and he hated nobody, He said that his experience of people were that they were sheeple, and I asked him, what does that mean? And he said that that was a combination of sheep and people. Sheeple was a combination, and that most people were sheeple or shepherds, and that he didn't like them.
Now, when you talk to him about these thoughts and he uses the word hatred, how does he say it? Can you kind of characterize it for us and why that was significant or not to you?
Sure. Very little emotion, very little affect around these kinds of statements, which had significance for us in trying to determine whether these were repetitive, long-standing, obsessive thoughts that he had had over the span of his life versus whether they were thoughts that were part of perhaps a delusional system or perhaps a psychosis. And that was a determination that we were trying to make, that I was trying to make during the 2 times I saw him.
Were you ever able to come up with a final decision based on the information that he provided you?
No, unclear.
And that includes both sessions?
That includes both sessions.
During the May 31st session, did you, based on the things that he'd been saying, did you characterize for him your belief that he had sort of a nihilistic view of the world?
I did.
How did he respond to that?
That led him to say, and I believe he understood that term, that he hated humanity, which then, again, while this came up several times, led me to be thinking about a violence risk assessment, which I routinely do in patients where you go through a number of checklists in your mind that help you potentially predict violence risk in a patient.
Let's do that. Well, first off, can you define for us what nihilism is?
So it meant sort of a dark view of the world, questions about morality, what was moral in the world, what was not moral in the world, and it seemed by his responses he understood what I was talking about.
You said you did a violence, what was it again?
A risk assessment.
Violence risk assessment. Now, we also heard from Dr. Fenton yesterday the term VASA.
Mm-hmm.
Do you know what that is?
Sure.
Is that, and tell us what that is.
Okay. So it's a violence and suicide risk assessment scale, which I developed in the 1980s and have been using subsequently.
I'm going to, if I can approach, please.
Yes? The objection is overruled. Why don't you ask the question again, Mr. Brockler?
Thank you, Your Honor. Doctor, I had asked you what the violence and the VASA tool was, and you were explaining what that was and how you came to know about it and use it.
Okay. So I developed that risk assessment scale when I was in New York City in the 80s and 90s, and have been using it since. It asks questions in several domains. The first question is, what is the level of the patient's ideation about violence? And there are rating elements in that, from a patient saying, I want to hurt somebody, all the way to elements saying, I want to kill a specific person at a specific point in time. So one of the variables you assess is ideation, and that was the variable that I assessed for Mr. Holmes. Second variable is whether or not they have a past history of violence. Past history turns out to be one of your best predictors of future violence. Next thing I asked about was recent events that indicate violence. Has there been any altercations, any problems with the law, any recent events where violence has occurred? Then you ask those same three questions about suicide. Does the patient have suicidal ideation? Again, describing a gradation of thoughts from, I sometimes think about hurting myself, to I'm planning to kill myself today, describing a variation of the person's thoughts. Same question about suicide, any recent suicide attempts, any past history of suicide would be the third variable, and that counts as 6 variables. And then you move down and ask questions about substance abuse. Is there a current history of intoxication or drug withdrawal, or is there a chronic history of drug abuse? You ask questions in that domain. And then you ask about support system. What's the support system? Because if you have a strong support system, it's less likely you're going to get violent than if you have no support system. And lastly, you use your subjective experience of the patient. What does it feel like with him? How concerned are you about him? And those come together with a scoring system that helps you decide, amongst other things, about how risky a person is and what the level of care
Your
that
Honor,
a person
I
may
need to object again. If I can approach, please.
The objection is noted. It is overruled for the same reason I indicated, but I'll let you expand at the break.
Okay,
All right.
thank you.
You may proceed.
Now, Doctor, it's not, just to be clear, this process, and you described how long you've been doing it, you're not sitting there with a specific score sheet marking X's and O's. Is this all inside your head?
Yes, it's got a score sheet that does have X's and O's, but I can do it.
Okay, and
in
was
my
this
head.
part of your approach to the remaining portion of this May 31st session that you had?
You bet.
Did you determine if there were any issues of substance abuse?
I understood that he had been drinking occasionally, socially, maybe a drink now and then.
But nothing that would impact this scale?
No serious use of any substance.
Did you ask him about whether or not he'd ever attempted suicide or felt suicidal?
I did, and he denied ever being suicidal, having any suicidal thoughts or ideation.
Did he tell you he was depressed?
No.
Did he appear depressed to you?
No.
Did he tell you he was feeling mania or manic?
No.
Did he appear to be experiencing mania or manic?
No.
Okay. In terms of the past violence, did you talk to him about that?
Yes.
And
We got no history of any episodes of prior violence anywhere in his history that he revealed to us.
did he share with you any specific targets or plans that he had regarding this homicidal ideation?
No, and I asked about that on several occasions. Does he have a specific target, a specific plan, a specific person in mind? And the answer to that was always things about hating humanity.
But nothing more than that?
Nothing more than that. Never a specific target or plan.
Had he told you at all that he was seeing things, hallucinations, audio, visual, anything?
No.
Did he tell you, as of that May 31st date, did he ever mention to you that he had signed up for Match.com?
No.
Did he talk to you at all about having purchased tear gas canisters,
No,
a gas mask and gas mask filter?
no,
Any weapons at all? Attempting to buy a handgun online?
no,
How about a cell phone stun gun?
no,
Folding knife?
no.
Would all of those things have been pieces of information that you would have loved to have had to factor into your analysis?
Objection, Your Honor, calls for speculation.
Overruled.
Yes, love to have that information. That's a key part to trying to help you make a good decision.
And did you provide him multiple opportunities during that May 31st session to give you that information?
Yes.
Did he seem to you at that session to want to rid himself of these homicidal thoughts?
Objection, Your Honor, calls for speculation.
You cannot speculate, doctor. You can testify based on your observations and things that you may have heard, but not speculate or guess.
Could you rephrase the question, please?
I will. Let me just go to something. Did he ever tell you, help me get rid of these homicidal thoughts?
No.
What was your understanding based on your conversation with the defendant on May 31st about what his goals for therapy were?
It was pretty clear he came in for help with public speaking, symptoms related to a social phobia, difficulty talking to people, speaking in a public situation. Mostly his complaints were anxiety. Initially, he came in reporting to us that he had trichotillomania and had some compulsions as well. And his initial presentation was treatment for anxiety and social phobia and obsessive compulsive symptoms.
In May 31st of 2012, did you discuss with the defendant the use of an antipsychotic?
I did.
What was that antipsychotic and why did you have that conversation with him?
I suggested that he take a medication called risperidol, and the way I led into that was I expressed to him my concern that he was having a nervous breakdown or might be having a nervous breakdown, and that medication was a good medication that would treat many things. It would treat his obsessions if he had obsessive compulsive disorder. It would treat a delusion if he had one. It would treat a psychotic process if he had one, and probably also help him with his anxiety.
And what did the defendant tell you about that offer?
Said no.
Anything else about that session that took place before you scheduled a follow-up session?
I did talk with him about school and how he was doing in school.
What did he tell you?
He told me that he didn't have a particularly good fit with his lab. I did ask him if he was studying, and he said he wasn't studying much and that he'd been playing video games, specifically Diablo 3, for many, many hours.
Did you express some concern with him about, hey, why aren't you studying?
I asked him why he wasn't studying more to prepare for his exams, and he said that he had got it covered. He knew how much he had to study, and he was doing an adequate preparation.
Seemed unfazed by that?
Completely unfazed.
Doctor, anything else about that May 31st session?
Only that we asked him if he would come back, and told him that we wanted to try to make a new treatment plan, and we asked him if he would come back for another session as soon as we could arrange that.
Did he agree?
He did.
Is that important that he agreed to come back for follow-on treatment?
Yes.
Why?
I felt that, at least I had hoped, and felt that maybe I had made a little bit of an attachment to him, that he was a little bit interested in our care and treatment of him, and I took it as a good sign that he was willing to come back and talk to us again.
At that time when he leaves Dr. Fenton's office on May 31st, do you believe that you have grounds to justify forcibly taking him off the street and putting him in a 72-hour hold?
No, we did not have grounds. He had no imminent risk of violence that we were aware of. He had no specific target. He had no specific location. We had no information that there was any imminent risk of violence from him.
Was there anything that you did between May 31st and that next June 11th appointment where you saw the defendant?
Dr. Fenton and I spoke about him after the session, and Dr. Fenton and I spoke again briefly before the next session.
So take us to June the 11th, 2012. Meeting at the same place?
Yes.
Dr. Fenton's office?
Yes.
Did the defendant show up on time?
He did.
Was he dressed really any differently than he had been a couple weeks before?
No.
Talk to us about his presentation to you when he came in for that meeting.
His presentation was very similar to the last time he came in, a brief eye contact and a nod, and he sat down in the same seat that he had sat in the previous session.
Looking at the clock, should I go?
Sure. All right, members of the jury, it's 5 o'clock, so we're going to go ahead and adjourn for the day. I'm going to go through the advisements with you. Please remember that you may not discuss any aspect of the case with each other through any means. You're free to talk to each other, but not about the case or anything related to the case. Number two, please remember that you may not communicate about the case with anyone else. What you can tell people is that you're on a jury and that we anticipate that the trial will go through August and perhaps the beginning of September. Number three, you may not have any contact or communications with any of the jurors who have been dismissed. And when I say no contact or communication, I mean exactly that. And so that includes physical contact, that includes, in other words, in-person contact, that includes by phone, by email, by text, by any means. Number four, please do not talk to any witnesses, parties, or attorneys about anything, whether related to the case or not. Number five, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. Your juror badge will reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. In the event that despite your best efforts, you hear something about the case, please let my staff know that you want to talk to me about something. Number six, please do not talk to any members of the media about anything. Number seven, you must not read, view, or listen to any news or media reports that may refer to the case. Because there is media coverage of this trial, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. Number eight, you cannot visit any locations mentioned in the case or conduct your own investigation outside the courtroom. That includes referencing treatises, books, dictionaries, or the internet. You cannot conduct your own investigation in relation to the case. Number nine, your verdict in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I give you. I know that I have phrased this particular advisement in different ways in the past. I mean the same thing. Your verdicts in this trial must be based only on the evidence presented in the courtroom and the instructions of law that I give you. To the extent that I refer to the evidence and information presented in the courtroom, I mean the same thing, the evidence presented in the courtroom. That's what I mean. It's based on the evidence presented in the courtroom and the instructions of law that I give you. Does everybody understand that? And everyone is saying yes and nodding their head yes. Number 10, you cannot start forming any opinions about the case until I tell you that you can start deliberating. And so not only is it improper for you to talk to each other about the case, it's improper for you to start thinking about the case and forming opinions about the case internally in your own minds. Number 11, neither sympathy for nor prejudice against the prosecution or the defendant may affect any of your decisions in this case. Number 10, please remember that the attorneys have a job to do, and sometimes they have to make objections. Please don't hold it against them if they do. Similarly, don't read into my rulings that I'm for one side or the other. I'm neutral in these proceedings, and I'm simply doing my best to apply the law. All right? Those advisements are all extremely important, and they're all mandatory. So please follow each and every one of them. Get some rest. I'll see you tomorrow at the usual time. Thank you very much, folks. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Dr. Feinstein, you may also leave for the day, and then we'll have you back tomorrow. My understanding is that you're returning tomorrow afternoon? Is that right? Yes. Okay. Tomorrow afternoon, your subpoena is continued until then, okay? Thank you. All right. I have a note that we need to talk about Ms. Mosher's testimony, which apparently the people are anticipating on Friday. Do the parties want to take up those objections at this time? Ms. Brady, is that a good time?
If that's what the court wants to do.
I'm okay doing it now, if you're okay doing it now. Okay. Okay, Ms. Brady, you may proceed.
Thank you, Your Honor. There's a whole list, and so what I would like to do is make all of these objections pursuant to Mr. Holmes' due process rights, rights to a fair trial, and rights under the Eighth Amendment. And then for each objection, I'll tell the court which evidentiary rule I'm objecting under.
Okay, thank you. That would be great.
I anticipate that Ms. Mosher will testify that she dropped her daughter Veronica off at the babysitter that afternoon so that she, Ashley, could go have an ultrasound. And I would object to that under 401 and 403. Do you want me just to do the whole list?
Actually, can you give me just a second so I can take notes? Okay, what's the next one?
She was excited about the new baby and wanted to go celebrate. 401 and 403.
Okay, go ahead.
She thought that the Batman, she being Ashley, thought that the Batman movie would be a kid's cartoon. And when she realized it wasn't going to be a cartoon, she thought, oh my gosh, I hope Veronica won't be scared. .401 and 403.
Okay, go ahead.
At the theater, Veronica wanted to sit on her mother's lap, and Ashley, since she was pregnant, did not want Veronica to sit on her lap because it was uncomfortable. And so the last thing that Ashley said to Veronica was, no, you're a big girl, you can sit in your own seat. 401, 403, and hearsay.
All right.
I expect the testimony to be that when Ashley Mosier was shot, she fell on top of Veronica, and then Ashley Mosier was asking the cousin, I believe her name's Kaylin Bailey, whether Veronica was breathing. Would object 401, 403, and hearsay. And then also to that, Kaylin Bailey's response, I don't know.
All right.
Kaylin Bailey asking Ashley Mosier if she could move off of Veronica, and Ashley Mosier saying that she couldn't. 401, 403, and hearsay.
Okay. What's the next one?
When Ashley Mosier was being carried out of the theater, her pants fell down. 401 and 403.
All right.
When Ashley Mosier got to the hospital, she remembers one of the medical personnel talking about performing a CAT scan on Ashley Mosier, and that Ashley Mosier was pregnant. Hearsay 401 and 403.
Okay.
At the hospital, Ashley Mosier asking her mother about the status of Veronica, and the mother telling Ashley that they were taking care of Veronica, and that Ashley finally found out on Sunday that Veronica had died. Hearsay 401, 403.
All right.
Ashley being told at the hospital that she lost her unborn baby. 401, 403, hearsay.
Okay.
That they had to remove the upper left lobe of one of Ashley Mosier's lungs, and that she still has to use oxygen at night. 401 and 403.
Excuse me.
Bless you.
All right. Any others?
She still has bullet fragments in her body and spinal cord. 401 and 403.
All right.
She had to stay at the Craig Rehabilitation Center from August of 2012 until December of 2013, 401 and 403.
Okay.
Your Honor, and then there's a string of things that she had to relearn how to do. I can give those to the court one by one or in a group. It's up to the court. Examples are how to use a spoon, how to transfer from the wheelchair to the bed, how to learn how to sit because her balance was bad, how to learn how to do quad coughs to get fluid out of her lungs and throat. I think they had her do something in a standing frame to keep her bones strong. She had to learn how to make a sandwich. She did physical therapy 3 to 4 times a week at Craig and no longer does the physical therapy. Accommodations that have had to been that they've done to enable her to use the restroom, bathe, dress herself. She's fallen a few times since then. She's had subsequent infections. They had to delay Veronica's funeral until a time when Ashley was able to be more involved in it and that she was unable to help plan it. She was in the hospital. There are details about her funeral. I don't know how far the prosecution intends to go, but these are, she still has nerve pain. And that would all be under 401 and 403. And then we would object to showing Ms. Mosier a picture of Veronica and asking her if she ever saw her daughter alive again. As the court knows, the death of the child strikes a particular chord for a lot of jurors. We're not disputing Veronica's death. The jury has heard a lot of information about Veronica's death, and it just seems that this is unduly prejudicial compared to its probative value. Would ask the court to exclude all of that.
All right, thank you. Who's going to respond? Ms. Stitch McGuire?
Oh, Your Honor.
Okay. And maybe the easiest way to do it is to go in the same order, and you can tell me whether you are intending to introduce the evidence that Ms. Brady talked about as to each category, and if you are, what the response is to the objection.
Yes, sir. Thank you. Just to capture overall, I think Ashley Mosier Sullivan represents a unique witness in this trial. We have had perceiving witnesses from the theater who suffered no injury. We have had witnesses who were victims of the defendant's conduct and have been injured and were able to talk about it. And we have had witnesses that were able to talk about the deceased that they were with. Ms. Mosier Sullivan represents a combination of all three. She's not only a perceiving witness, she was one that suffered a significant injury and also was the parent of one of the defendant's victims in this case. And so she is a unique person when she hits the stand here, the judge, to testify. As to the initial things that Ms. Brady brought up, about her dropping her daughter off at the babysitter and the fact that she had gone for an ultrasound, they were excited, and they thought that, she thought that Batman was a cartoon movie. These are all things, Your Honor, that put into context for jurors how they got to the theater that night and why a 6-year-old girl, and we've heard about other children, would be at a Batman movie at midnight on a Thursday night. It also goes to put into context some of the later testimony about her injuries, including her miscarriage. There is nothing gratuitous about that. There is nothing that is unfairly prejudicial to the defendant. And that's the other portion of this. is that I agree with Miss Brady. It is a horrific thing to deal with the murder of a child. That is what the allegations are in this case. So there isn't any way to pick apart all the other surrounding evidence to say, let's minimize the emotional impact of killing a 6-year-old. The fact that she does not want her to sit on her lap, Your Honor, is significant and arguable because it explains why she was in the seat that she was in when she had an alternative, when she suffered the 4 shots to her body that the defendant put into her. That's significant. The fact that there was... I'm sorry.
Why, who was in that seat?
I'm sorry, why Veronica was in her own seat when she had wanted to sit on her mother's lap. It puts into perspective for the jurors what was going on, why she ended up being in that seat by herself. And she ends up getting shot in that seat or right there as Mom's trying to pull her down. There is an objection to whether or not Veronica was breathing, and it was whether or not Ashley could perceive her breathing and her statement afterwards. And I think, Your Honor, that's a present sense impression that she has. I don't think it's hearsay. I think it goes to that moment when her thoughts, her only thoughts, as she's on top of her daughter, are, is she breathing? The statement that she couldn't move, and I'm willing to accept that the question by Caitlin, can you get off of her, maybe hearsay, maybe that doesn't come in. But
I think before that,
yes, sir.
The statement by Caitlin, I don't know, in response to the question about whether Veronica was breathing.
It's possible it's an excited utterance, Your Honor, and we'd have to lay the foundation for that. But I'm not wedded to that, Your Honor. There's also, the fact that Caitlin doesn't know if she's breathing has some relevance and significance, but again, Your Honor, it's a hearsay statement. It may be an excited utterance. And I'm sorry, Your Honor, I was addressing the
question by Caitlin, if she could move off of Veronica.
Right. I think the reason that is admissible and comes in and isn't 403 is it then leads to the victim in this case, Miss Mosier Sullivan, to try to move and realizes she cannot move. And this explains her then response, no, I can't get off of her. It's a measure of the injuries that she sustained immediately after the shooting. Her pants fell down as she was being taken out of the theater. Your Honor, I don't know that that's unfairly prejudicial. It's simply a fact of how she got from the crime scene to where she ended up being treated. It is a reality of the situation that was created by the defendant. The statement by the medical person that they wanted to CAT scan her because she was pregnant. All right, I do think that's a hearsay statement. I don't have a good answer for that at the moment. Judge, if the court would permit, I'll try to think of something overnight, and I know the court's going to think about this too, but I think it's hearsay.
I think it is too.
Yeah, the mother telling her that they're going to take care of Veronica. Well, I think that is the reality of the situation. And I think it goes to try to assuage the angst that she's going through in the hospital. And Judge, you'll remember this was the objection where the mom, I think, is coming to see Ashley and saying, hey, they're taking care of Veronica. I think that is likely also hearsay.
So you agree that that's hearsay?
I think it's hearsay. I think that the issue, though, of her finding out on Sunday, being told that her daughter died, Judge, I do think that's relevant. I mean, she finds out at some point that her daughter is dead. I think on that too, Judge. The fact that she lost her unborn baby, this is no different, Your Honor, than being told, your bone was broken or the bullet perforated your liver. These people that have testified to these injuries don't know it because they've seen it. They know it because they've been told it by doctors, and they've lived with the consequences. And here, to not permit her the opportunity to describe her injury, an injury, significant injury of the loss of this unborn baby that she just had confirmed was alive earlier that day, would put her in a far different position than all the other victims who've been allowed to testify about their injuries. The fact that she still uses oxygen at night, I think, goes to the extent of her injury, Your Honor. And there's a way to do this without belaboring every single consequence. But certainly they have to know the fact that she lost part of her lung and the consequences of it through a couple questions and answers is not unfairly prejudicial, but is a measure of the injury that the defendant inflicted. And that includes the bullet fragments that remain in her body. We've had several people, including today, witnesses testify about shot that remains in their torso, in their limbs, and even in their face. She was at Craig Rehab Hospital from August 12th to December 13th. That singular fact does not create unfair prejudice, Your Honor. If we were to go down the road of every single thing that she had to endure, and there's a ton, over those 16 months, that would be potentially unfairly prejudicial. But the fact that their injury was such that she was at Craig Hospital for that period of time, Your Honor, I don't believe is. And I see Ms. Brady standing up. Should I stop talking?
He just said from August 12th to December 13th. I just wanted to make sure that the record was clear. It's from August of 2012 to December of 2013.
And that's how I understood it.
And thank you, Ms. Brady. If I misstated that, thank you for clearing that up. The ongoing infections, her falling, the funeral information, while I think that is relevant, Your Honor, incredibly relevant under 401, I do also think that there is a legitimate 403 argument to those aspects of this. And if I've missed something, Judge, would you tell me and I'll give you my thought on it?
So on the string of things, you agree that those should not be admitted?
Well, not on the entire string, Judge, and thank you for catching me up on that. There are some things where she talked about having to figure out how to use a spoon again is a measure of how that injury has affected her in a different way. They can be told that she's paralyzed as a result of this and that she can't walk, but to not understand how it's affected the rest of her body and her limbs, I think it gives them a false impression of the extent of the injury. The funeral part, I'd love the jury to be able to hear that, and maybe someday they will. The falling down, all of those other things. But I do think that at some point we get into the area of 403 if the court permits all of the other prior things in. Is there anything else, Your Honor, I might answer?
I think Ms. Brady listed nerve pain as one of the string of things. Is that something that you are agreeing to not include, or do you want to respond to that?
I think nerve pain, Your Honor, should be admissible. I do not think that's unfairly prejudicial. I do think if we were to ask for a string of examples of how that nerve pain manifests itself, that would be 403. But the fact that she suffers nerve pain and to ask her what that means in a limited capacity, I don't.
And the last thing I have is showing her a photograph of her daughter and asking if she ever saw her alive again after the movie.
Judge, honestly, with all the respect in the world due to Ms. Brady, it is inexplicable to me that we could go through the testimony of this mother and not show her a picture of her daughter and not only have her identify that daughter, but at some point during this discuss with her the death of her daughter and whether she's seen her again. And I don't know that I would use those words, Judge, but certainly the picture, showing her the picture, has to be something that we allow. That can't be unfairly prejudicial.
Okay, thank you. All right, I'm going to think about these things. Ms. Brady, I'm sorry, did you want to add something? Why don't you go to the microphone?
About the picture, Your Honor, I would just ask, what is the relevance of that? I mean, I think the point of that is so Ashley will start crying, as would any mother. It is to start crying, to evoke sympathy from the jury, and there's no relevance. There's no dispute that Veronica is Ashley's child, that Veronica died, that is a tragic, tragic occurrence. If there was any relevance, I wouldn't object. There's no relevance, and extreme prejudicial evoking of sympathy from the jury. Everyone in this courtroom will be heartbroken to watch Ashley see a picture of her daughter. And that's the point of showing the picture. With all due respect to Mr. Brockler, that's the point of it. It's not because anyone in here doubts that Veronica is Ashley's daughter, that Veronica died, that is heartbreaking. And so I see no relevance. I get why you would want to do it, but this is a trial and there has to be relevance to it, and the relevance has to overcome the prejudicial effect. And I think this is an easy decision that the prejudice of that way outweighs the relevance. So that's my last comment.
All right, so both parties believe it's an easy decision, but both parties come out different ways. All right, fair enough. Thank you. All right, is there anything else we need to talk about at this time on behalf of the people?
No, Your Honor.
Oh.
Okay.
Sorry.
Ms. Teach-McGuire.
We got a couple of court exhibits looks like denied evidence at this point. CTR 68 and CTR 69, if I can present those, Your Honor.
Okay, thank you. And why don't you state the people's exhibit numbers with respect to each, just so that the record is completely clear.
Thank you, Your Honor. I neglected to do so. I apologize. CTR 68 was proposed People's Exhibit 4658, and CTR 69 was People's Proposed Exhibit 1102.
All right, thank you.
I don't know where
You can just put them right there. Okay. Thank you.
Judge, if I could supplement Mr. Orman's record, that 1102, that's the original copy that was taken off and then ultimately redacted. So that CT is the one that was unredacted for the court.
Okay, thank you. Anything on behalf of the defense? Ms. Higgs?
Yes, Your Honor. I think the court granted me permission to expand on my previous objection with regard to Dr. Feinstein's testimony.
Yes.
I had indicated at the bench that part of my reason for objecting to his testimony was the Eighth Amendment, and I think that it is now particularly ripe since what this court has done is allowed. And I would note that when Mr. Brockler was direct examining and Dr. Fenton was testifying yesterday, there was no specific delineation of every single factor of the violence risk assessment. Now, this doctor has gotten up, George Brockler has been allowed to ask about his 30 years of experience and all the patients that he's seen, and that he's used this since he worked in New York in the 1980s, and this witness has been allowed to testify to this jury in the merits phase of a capital case that past violence is the best indicator of future danger. This is tantamount to the court allowing the prosecution to rebut a mitigator in the merits phase of a trial in a capital case. And so I think that it is important to make that record, to make sure that the court is aware that my objection was also based on the Eighth Amendment of the United States Constitution, as well as my client's rights under Article 2, I believe it's Section 20 of the Colorado Constitution, against basically his right to a fair and reliable sentencing hearing and his right to be free from cruel and unusual punishment. I would ask this court to strike all that specific testimony discussing this violence risk assessment. I don't think it is necessary for this testimony. This doctor could have easily said, you know, I talked to him about his homicidal ideation, I talked to him about suicidal stuff. What we determined was that there was no risk here for these reasons. He didn't give us this information. So I wanted to make that record clear.
All right, is there any response from the people? Do you want to respond?
Just briefly, Your Honor, and the court has made a pretty good record at the bench already. Your Honor, all of these questions that I have asked him have been to have him explain why he did what he did in terms of asking questions and making decisions. There has been nothing gratuitous in a single question that I have asked. As to Rebecca Higgs' suggestion that I have tried to attack a mitigator before we've even gotten there, I'm telling the court, I have no intention of arguing to anyone at any time in the guilt phase of this case that that statement is somehow a reflection on how they ought to approach either guilt or sentencing. He was discussing the steps that he went through in asking the defendant about his clean criminal history and no prior violence as part of his thought process as to why he didn't commit him which is an issue that the court knows from Dr. Fenton's testimony yesterday, is not only of some significance to the defense, who tried to admit the law on that, but jurors who asked questions about it. There's been nothing gratuitous or, I think, in violation of any of the court's rules in this case. This is necessary for a treating physician to explain why they did what they did. In the absence of it, he's just saying, I did X, Y, and Z without explanation, and that doesn't make sense.
I agree with Mr. Brockler, and I agreed with him at the bench. I continue to have the same ruling. Ms. Higgs did not add anything in terms of a legal ground to the objection. She just made it more emphatic. So it was objection the first time. I think the second time I heard it as, I strenuously object. She made the same objection, the same legal grounds, and the objection's overruled. There's nothing improper from Dr. Feinstein's testimony thus far. He was asked a question about what he did. He's entitled to talk about what he did. Part of what he did is a violence and suicide risk assessment, and he did that using a specific paradigm or material that he invented, that he came up with. And so he was asked, well, what does that involve? And then he had to talk about that. I agree with Mr. Brockler. This is an issue that is of importance to both parties, and both parties went into it yesterday with Dr. Fenton. And so it's, again, the kind of thing where you can't go into it with one witness and then say, well, wait a minute, now we don't want this other witness to address it. They both were working together. Both of these witnesses were working together, especially in April and May of 2012. And so there's absolutely nothing improper with this testimony. The fact that someone could use the information to make an argument that might rebut a mitigator doesn't render it inappropriate in the guilt phase of the trial. What's important is that it not be presented in that fashion to the jury and that it not be argued that way to the jury. There is no way that any of the jurors heard that testimony and they're thinking in terms of mitigators and in terms of how that rebuts a mitigator. I'm trained in the law, and I'm not even thinking that. I would never have thought that if it wasn't for Ms. Higgs bringing it up. And so I think it's a reach at best, and so the objection is overruled. All right, I'll see you tomorrow. The court will be in recess. Thank you. Oh, sorry, hold on. Ms. Spengler has one thing. Ms. Spengler?
I know it's late.
That's okay.
I expect the Hotmail exhibit will be attempted to be introduced tomorrow, and Mr. Edson drew the court's attention to that Hotmail exhibit. I can tell you that there are still several areas of disagreement, so there will be argument. I expect that argument would take approximately 10 minutes. I can tell the court also I would like to review some of the exhibits early tomorrow morning to more specifically identify cumulative arguments. So if we can make argument tomorrow morning, or if the court wants to hear argument now, I'm prepared to do that now.
Are you anticipating this coming up in the first part of the morning or the second part of the morning?
Ms. Teach McGuire is telling me, and it's Mr. Edson's evidence, but that it would probably be after the morning break.
Okay, let's take it up at the morning break then, okay? All right, thank you. All right, the court will be in recess. Thank you. Hey, Joyce.